We're going to start early.
Welcome, everybody. My name is Sarah Luddington. I'm going to be the moderator of this panel. And the program in public law is very pleased to sponsor today's panel discussion on the timely topic of trying cases in the media, the role of the prosecutor and the press. We have 4 distinguished panelists today. Each of them is going to give a brief presentation on today's topic, and there will be time for questions from the audience after their presentations. Our panelists include, in order of speaking, Professor Tom Metzloff, who teaches courses on ethics and professional responsibility at Duke. He's also an advisory member of the North Carolina State Bar Ethics Committee. And just to clarify, that is not the committee that has been involved in indicting Mike Nifong for ethical violations in his handling of the lacrosse case. Next will be Joseph Neff, who's an investigative reporter at the Raleigh News and Observer. He's written extensively about problems in the criminal justice system. He's also covered the Duke lacrosse case for the News and Observer. Next will be Professor Jim Coleman, who's had a distinguished career as a criminal lawyer and now teaches criminal law and legal ethics at the law school. Professor Coleman recently chaired the university's investigation into the lacrosse team. And finally, Professor Michael Tigar, who teaches criminal law at Duke and has been defense counsel in many criminal cases that attracted media attention. Just to name a few, the prosecutions of the Chicago 8, the Seattle 8, H. Rap Brown, Kay Bailey Hutchison, Angela Davis, Lynn Stewart, and Terry Lynn Nichols. Professor Tigar also represented the petitioner in the Supreme Court case, Gentile versus State Bar of Nevada, and that case tested the constitutional validity of ethical rules that limit what a defense attorney can say to the media before a trial.
Thank you. It's a pleasure to be here today, and I really want to primarily talk about the recent ethics charges against Mr. Nifong. I know there's quite a bit that could be brought up broader with this topic, but this is a case that's already captured the attention of ethics teachers in classes across the country, and depending on how it plays out in terms of opinions, I think this may truly be one of the leading cases that we will be talking about and thinking about in law schools for quite some time. So I don't want to pass up the opportunity to do what we do in law school and kind of think of this as the case method. I've had the pleasure to be talking with the press, as probably anyone who teaches ethics has been in the last couple of weeks. And I've gotten some questions. And the first question always basically is, what's your take on the ethics complaint against Mr. Nifong? What's really the heart of it? And yesterday we had what was the next sort of bombshell in a series of bombshells when the State Bar of North Carolina amended its complaint to add a series of charges against Mr. Nifong for failure to turn over exculpatory evidence, as well as making misrepresentations to the court. And the conventional wisdom after one day of press reports is that that's the story. That's the most serious charge, and that's not what I was saying yesterday. And in some respects, that's probably why I wasn't quoted as much, because if you don't say what they want sometimes, and in quite the right way, you're buried at the bottom of the article, if at all. And that's never been my goal, so that's all right. So that's really part of what I want to say today. I think the serious charges were the initial charges that the State Bar filed involving the pretrial comments, the publicity issues, and I want to kind of focus on that today. These new charges are serious, but I hope that they do not come to dominate the case, because I think we will have missed an opportunity to really think about what is the role of prosecutors in cases today. So let's think about what the State Bar's got to prove. The State Bar has a responsibility, if they're going to prevail in their case, to prove by clear, cogent, and convincing evidence. So it's not really a criminal case, it's not really a civil case. So it's clear, cogent, and convincing evidence. I always thought it was just clear and convincing, but they threw cogent in the middle. To find him guilty. Now, the rules do speak of guilt, so it's appropriate to speak in those terms. There's really 2 basic rules, and Professor Tigar has written them on the board over there, Rule 3.6 and 3.8. And those are the right place to start. I don't think they're necessarily the right place to finish. And at the end, I want to speak about some other rules as you really try to understand the essence of what the State Bar of North Carolina has done. Rule 3.6 deals with trial publicity. A lot of us in the room are lawyers. What are the elements of the offense? You first have to see, did he make extrajudicial statement? An extrajudicial statement. It's in the singular. The State Bar complaint is certainly in the plural, as it has about 85 different statements that were made, that he knew would be disseminated by means of public communication. That's a no-brainer here. We know that these were statements given to the press. So we get past the initial sort of element of the offense here. So why do you even have that rule? Well, sometimes prosecutors might make statements as part of their investigation. They don't expect the reporters to pick them up, and they get them from a leak or something else. There's no issue there. What do they have to prove then to win? They have to prove a substantial likelihood of materially prejudicing an adjudicative proceeding, a trial. And this is a formulation that's infused with constitutional doctrine, and in many cases certainly would beg some questions, but not, I don't think, in this case. I don't think there's any significant doubt that there was substantial likelihood of prejudice in this case. And I turn simply to the issue of change of venue. It's a motion that's pending, and I suppose arguments could be made that it should or should not be granted, but I think this is probably, if Mr. Nifong was still on the case, about the easiest change of venue case that one can imagine. And I offer myself as exhibit, as sort of the first witness. There are cases that have lots of publicity. We've had them in Durham. Some of you say, why does Durham generate these cases? Michael Peterson was my neighbor and was accused of murdering his wife a couple of years ago. And for those of you not from Durham, it's hard to believe that case probably had as much local coverage as this case has. Hard to believe, but it's true. I read every word of it. I talked to my neighbors. I was fascinated by theories, defenses, whatever. If I had been called for jury duty, I would have looked the judge in the eye and said, yes, I can be on this jury, I'll do my best. In fact, I'm really quite fascinated by figuring out whether this was or was not the case. I couldn't do that in this case. If I was on the jury pool, called down for this case, if Mr. Nifong was still the district attorney, I would say there's no way in the world that I could be a juror in this case. I would have too much sort of animosity, too much concern, too much anger, and it really is anger about the comments that were made by him in light of what happened. And I think that's true, and I suppose everyone in this room who's a Durham citizen can answer that question for themselves. But I know my wife would be unable to do that. I've asked her. Many of my colleagues have said to me when I've asked, no, I couldn't be on that jury. We had a jury pool that I don't think this case could not have been tried in Durham. With new prosecutors, it's maybe the case. Both my kids could not do it, too, and both my kids have been called for jury duty. You know you're getting old when your kids have been called for jury duty. So what does that mean? I couldn't have given the district attorney a fair hearing in that case, and I think that, in a sense, proves the substantial likelihood of prejudice. So we've got a violation of Rule 3.6. But I think we have to sort of say, what kind of violation do we have? Here's the other question I've gotten from reporters since the State Bar filing. Which of the comments was the worst? What's the real essence of what's going on? It's a fascinating question. It's a good question. It's an important, in a sense, ethical question. Let's talk a little bit about what Rule 3.6 says. It's a laundry list of what you can say, primarily. And it's a little bit like Joe Friday and Dragnet. It's kind of just the facts. The rule anticipates that you talk about some specific facts about the investigation and the charges. You can talk a little bit about how dangerous a defendant is if they're on the loose, because there's a sense of having to warn the public. I don't think that's involved here. I think we have to be the clearer definition comes from Rule 3.8. Rule 3.8 is special ethical responsibilities of the prosecutor. And people have said, well, haven't the defense lawyers been just as bad as the prosecutor in this case? And there's comments there. But Rule 3.8 is a special rule for the prosecutors. And it says that you should refrain from making comments that serve to heighten public condemnation of the accused. And that's really one of the keys to the cases. That rule makes sense. We want to avoid vigilante justice in this country. We've had issues with that. People have enough strong feelings about the accused. And what this rule says is a charge to prosecutors to be aware of and careful about that. And so when on 60 Minutes 2 weeks ago you hear parents talking about receiving death threats, if that's true, you understand that that's a rule that makes sense and a rule we need to worry about. Another question I sort of get asked a lot is, well, how is Mr. Nifong going to defend himself? What are the defenses? Well, Rule 3.8 talks about this sort of creating this, extraneous negative effect on an accused. And many of these public statements were made before anyone had been arrested. And I suppose there is a technical defense there, that there was no accused at the time when most of these statements were made. And so one will have to think about that. There's certainly potential First Amendment arguments. Rule 3.6 is a balancing test. There's lots in the comments about the importance of free dissemination of information about our justice system, and it's to be balanced out. But many of the comments there, and many of our ethics rules, you find much more detail and much more content in the comments than the rules themselves, are very specific, and they provide specific examples of comments that, if made, it will, in a sense, be presumed, or we will assume that they will have a material prejudicial effect. And one of those is on the character of a party who's been accused, which is, I think, why even early on Mr. Nifong said, I shouldn't have made that comments about hooligans. Now, I don't know what emotional reaction one has to about a hooligan. I think of some soccer player in England, but that is the one statement because of this specific reference. He said, that, I wish I hadn't said that. But more fundamentally, the comments talk about any comments being prohibited about the opinion of guilt or innocence of a defendant. And I think that's, when I asked, when given the question, what's the worst thing, it's, I think, all those comments. There are some defenses in the rules themselves. Rule 3.8 talks about legitimate law enforcement purposes. Now, that could be one of those sort of exceptions that sort of swallows the rule. That can mean anything and everything, and we don't have a lot. And I expect Mr. Nifong to come up with some suggestions as to how this might be a legitimate law enforcement purpose. One of them is to get other people to come forward with comments. And I think some of his comments were trying to encourage other lacrosse players, believing that a crime had been committed, to come forward and say something. So he may find some aspect there. But a lot more will be sort of the more general characterization of Nifong of why he did what he did. The argument is likely to be, I was a political novice. I got caught up in a political moment that I didn't know what to do. And who can blame him at some respects for not knowing how to play the juggernaut of national press, bloggers, and the like? As Mr. Nifong has said, this is a paraphrase, not a quote, I didn't learn about that at law school. And I suppose there's something to that. So it's spur-of-the-moment defense, riding the wave. And part of the reaction is, well, it was a very long moment. That might excuse a day or two. I think the alternate view, which is certainly going to be the state's bar's view, is not that political novice doesn't count. This is about lawyering, a 25-year veteran prosecutor. These rules are not obscure nor technical. I have tried this. I have given the table of contents of the ethics rules to a non-lawyer and said, all right, you're a prosecutor. You need to figure out what you can say in the press. Go. It takes about 15 seconds to find Rule 3.6 and 3.8. There are only 59 ethics rules in the book in North Carolina. The one that says special responsibilities of a prosecutor calls your attention quickly. These are not obscure. They're known. It would take 10 minutes to read them from front to finish. The next question I get is, if Nifong is guilty, what's the punishment going to be? And certainly here, this is where it gets interesting. There is no database of disciplinary actions in North Carolina that would permit us to assess how many Rule 3.6 cases there have been, 3.8, and what the outcomes have been. From what I can gather, that there have been several actions under these rules, usually resulting in the grievance committee making the determination, not sending it to what we're doing as a full trial. The grievance committee can itself mete out the punishment, and that we have situations with quite a few reprimands, private reprimands, and an occasional censure, but none that have gone to the full trial on these rules. Most commentators predict, yes, on publicity, a violation, and some kind of a reprimand, low-level punishment. I don't think it's going to be that simple and not so fast, because the allegations in the state bar did not stop with just 3.6 and 3.8. And there's another rule that has to get added to Professor Tigar's list. They very deliberately added a violation of Rule 8.4, misconduct, and they did not need to do that. You could have had a violation of these publicity rules simply under 3.6 and 3.8, but they went to include that Mr. Nifong engaged in conduct prejudicial to the administration of justice, and what the news reports picked up, engaged in conduct involving dishonesty, fraud, deceit, and misrepresentation. This is before the DNA charges that were in the amended complaint yesterday. And this is very deliberate and something that I don't think has been picked up on and appreciated to quite the extent that it should. They did not have to do that. And I think what is significant about the bar's complaint is not that Nifong said more than he had said, or said things that lawyers, especially prosecutors, are not supposed to say, but that what he did say misrepresented facts as he knew them, according to the State Bar's allegation. That is why I think the State Bar's complaint was not filed until after the DNA hearing in December. I think that is, and I have no doubt in my mind that the complaint evolved as events in November and October took place. They determined to proceed with the charges in October, and it took 2 months for them to hire their lawyers and write their complaint, and I think, in a sense, add to the gravity of the charges even before the DNA. The tenor and the severity of the charges are a function of the continuing meltdown of the factual underpinnings of the case and the investigation conducted by District Attorney Nifong. So how does the State Bar prove prejudicial to the administration of justice? Because I think in many respects that's what's interesting about this case. That's what the focus, not the trial itself. You can change the venue of the trial. The DNA evidence, the misrepresentations, the defense now has that information. They're able to, if the case continues, they'll be able to defend themselves. So I think what remains is what is the impact of all these statements that have to be interplayed with the factual underpinnings of Mr. Nifong's case, and what does it say about the appropriate penalty? And I think the more we learn, the more we are, I think, forced to think about more serious sanctions for the conduct involved here. I do think it's difficult, and I think the State Bar should think hard about how to assess the impacts of these statements on the administration of justice. If I were really trying to understand the impact, it's not simply the impact of the parents of the lacrosse players. It's not the impact on the jury pool, but rather, in some ways, the leaders of Durham, Mayor Bell, the leaders of Duke University, President Broadhead and others, the leaders of North Carolina Central, President Ammons. What did this mean? Was it necessary? Did it play any purpose? And in a sense, what has it said to so many people as they look at the justice system in Durham, North Carolina, and the United States? Those are difficult questions, but I think those are very much the questions that this case raises. And I hope the State Bar will grapple with them and present that full case to the hearing commission. Thank you.
Okay, so I'll be very brief. I have been a frequent critic of Nifong from almost from the very beginning. In March, I took a 1-month break when I was chairing the committee that reviewed the conduct of the lacrosse team, and then I resumed my criticism after that. And I say that to make this point, that my criticism of him had nothing to do with whether the students were innocent or guilty. It didn't matter, in my view. It didn't matter that they were Duke students. I would have criticized him in the same way, using exactly the same terms, if they were students at Carolina or Central, or if they were not students at all. I had 2 specific concerns, and then I had one overarching concern. One of my specific concerns was that I thought that in the very beginning, his statements were racially inflammatory, and they were made in circumstances that appeared that it was intended for political gain. I think that he knew that what he was doing would increase racial tensions both in the city and in the university, and I think that to a large extent he was pandering to black voters in Durham during the primary. I also thought that his statements were intended to cause public condemnation, not only of the 3 suspects in the case, but also the entire lacrosse team, and even more generally than that, I think of what he considered to be privileged white students at Duke generally. My overarching concern was that because of his statements and the effects that they were having, both in Durham and within the university, that he increased the chance that some of the students would be wrongfully charged, and perhaps that some would be wrongfully convicted. That was my principal concern. I think it meant that he would not be objective in overseeing the investigation because he clearly at that point had taken over control of the investigation. I thought that his statements made it unlikely that he would be objective in overseeing it. Normally, the prosecutor gets involved in an investigation to make sure things are done right. I think he was involved in the investigation in a way that was destructive. I think it also would mean that he would not be objective in evaluating the evidence. And then finally, I thought it meant he would not be objective in exercising the broad discretion that he has whether to bring charges. I think it also put pressure on the police to focus the investigation in a single direction and to ignore facts that were inconsistent with what their theory was of what happened, and also facts that would lead in a different direction. And I'll give you two examples and then I'll stop. The first example is what happened with the DNA evidence that the laboratory discovered that in fact there were samples of biological evidence taken from the woman who made the accusation that were not deposited by any of the Duke lacrosse students. They decided to suppress the disclosure of that evidence, and they did not pursue it. So what that meant was that everybody talks about, well, you know, maybe one of the reasons that the woman who made the accusation has not been perfectly clear in the various statements is that, you know, this was a traumatic event for her, and so maybe she got some of it wrong. Well, okay, let's assume that that's the case. Here is evidence of biological evidence from unidentified men. If, in fact, she had been sexually assaulted, then these are suspects, right? If you believe that there was a sexual assault and you can't identify the source is not the Duke lacrosse players, then who are the people who provided this evidence? They didn't pursue it, and instead they also suppressed it because it negated the prosecution's theory of what the Duke students allegedly done. And then the other example of this is the manner in which the lineup was conducted. I think that everybody involved understood that it was done improperly and that it would lead to only one result, which is that if she chose to identify any suspects as the people who allegedly attacked her, the suspects would be Duke lacrosse players. I think they knew that was wrong, but again, what it suggests is that both in terms of the DNA evidence and in terms of the lineup, that they had committed themselves to bringing a case against Duke lacrosse students, and that was the direction in which they went.
Okay. Thanks for having me here today. I'm talking today as I'm not a lawyer, I'm a reporter, I'm not an editor, which that means I'm speaking as a grunt on the ground and not an officer making decisions. These are my personal opinions, which can and very well may be disavowed by the News and Observer and the McClatchy Corporation. The topic is on how to cover high-profile cases, and I think I can better address how not to cover these cases as much as how to speak about how to cover cases, because there really is no perfect recipe, but there are pitfalls to avoid. If you think about the coverage of this case, from the beginning, it soon turned in from a criminal case investigated by the police and filed at the local courthouse into an investigation of someone else's investigation. And as a reporter, that just scares me, investigating someone else's investigation. There are lots of hidden agendas out there. The facts are hidden in someone else's file, and they're not public. There's conflicting agendas among all the people, the defense, the police, the prosecutor, whoever. And reporters have a long history of getting in trouble in cases like this. Think of the bomb in Atlanta in the 1996 Olympics, and Richard Jewell was the FBI's prime suspect in that case, and he eventually went on to collect over $2 million in damages from the local paper, and I believe CNN, though I'm not sure of that. But they relied on anonymous sources. The facts weren't all known, and they regretted it. Right now, a lot of reporters, several reporters at the AP, the Los Angeles Times, and the New York Times are going through a similar lawsuit in the Wenho Lee case about the physicist in Los Alamos, New Mexico. And there again, you have a case where reporters are investigating an investigation, and there's problems that come up with that. One of the most stark examples of this, there was a murder of 2 college professors in Dartmouth in February of 2001, and 2 veteran reporters from the Boston Globe relied on trusted yet anonymous law enforcement sources who they had had a long relationship with, apparently, and they wrote a front-page story that these 2 professors, the murder were crimes of passion, most likely resulting from an adulterous love affair that one of them was involved in. Well, the next day, investigators obtained arrest warrants for 2 Vermont teenagers totally unassociated with these 2 professors, and the following day, the Boston Globe stripped a huge front-page apology across the front of their paper. So the moral of that story is my second point, is that you have to be really careful in using anonymous sources in situations like this. I'm not against, it's not absolute, never use anonymous sources, but they have to be so carefully used and carefully vetted, and only in certain situations. If I was covering the CIA or the National Security Agency, to talk to anyone, they're breaking their own in-house rules, and maybe they're committing crimes by even talking to a reporter or leaking information. Well, there's no other way to report those stories without using anonymous stories. If there's a whistleblower, someone who's going to get retaliated or fired against, yes, we'll give them anonymity. But I'm really leery of giving anonymity in a routine criminal case like this. I mean, who are you giving anonymity to? Well, you may be giving it to the police department or to the DA or to the defense attorneys. They all have their own agendas, and I don't think that that's a good thing. And I don't think that if you look back over the news coverage of this case in the first couple months, there have just been amazing things reported that are just not fact. And the problem is usually that it's not from a document, or it's not from someone who's stood up and attached their name to it as a source. So we haven't used any anonymous sources in this story at the News and Observer, with one sort of exception that proves the rule. In a moment of madness, earlier, just recently, there's all this rumor going around. Greta Van Susteren has this the cousin of the accuser in this case, named Jackie, on TV reporting that this woman has given birth to her baby, and it's 9 months after the attack. WRAL is reporting that they have learned that the woman has given birth. The officers called, the grunts responded. We could not nail it down that evening, so the paper went ahead over the objection of the grunts and said that WRAL has reported that she's had her baby. Well, the next morning, and our argument against using that was that not only is this an anonymous source, but we don't even know who the anonymous source is. Next morning, WRAL reports that she did not have her baby. And I think that that's one of the reasons why we don't use anonymous sources. Another point I think is a pitfall for reporters is to beware, for lack of a better word, meta-narratives. Things like early on in the case, or you'd read, if you read news stories, you'd read things like this: national cause celeb, yet another painful chapter in the tangled American opera of race, sex, and privilege. Now, put aside in the fact that operas have acts and not chapters, but someone, probably my executive editor, looked at that paragraph and said, "Oh God, that's an editor putting in there. They're trying to attach some big, theoretical story on top of that, or, the edgily cohabitated southern world of Duke and Durham." And I've lived in Durham for 14 years, and I didn't know how edgily cohabitating I was, But the problem with these, or the academia riven by politically correct leftists or whatever, all these, they become, for reporters, they become Procrustean beds. Does anyone know, Procrustes was that Greek highwayman, and anyone who came by, he would offer to spend the night, he'd put them on the bed, tie them down, and if they were too short, he'd stretch them, and if they were too tall, he'd chop off their legs. And that's what happens when you get wedded to these meta-narratives. When the facts start coming out, you're fitting facts to fit that. And I'm big on the narrative story form, but it's got to be built on a bed of facts gathered through your traditional reporting. So I have a couple ideas on how you should report a high-profile story. We're in an enviable position here because we're just a local paper. We have someone who covers the police department. We have someone who covers the Durham courthouse. We have a reporter who covers the city hall. We have a reporter who covers the county commissioners, another one who covers the Durham neighborhoods, another one who covers Duke. So one of the things to do with a news story is just cover it like any other news story. Just this case, we had to throw a lot more people on it. And you just cover your beats and you do your basic reporting. If you start off by just covering like a beat reporter, I think you'll do a competent job and you won't make any mistakes on it. I was brought into this, I was out of town for the first 10 or 12 days of this, when this news broke, and when I came back, I was assigned to the story with this a simple mandate. Go out and find the second dancer, which I didn't do, even, I failed on that. And there's when we were watching 60 Minutes, the first show, at the end of the show, my wife turns to me and says, I know that woman, that Kim Roberts woman. And I said, really? And she goes, because she's very organized, she runs and gets her date book and pulls back and says, yeah, her daughter had a play date with us back on November something, 2003, and she came over to pick up her daughter. So I was assigned to the story as my first job, and I could not find the woman who had actually been at my house. But my editors, they know that now. They kept me on the story because they suspected that there was some official misconduct and prosecutorial misconduct going on. And so they kept me on the story because I've had a lot of experience writing about prosecutors. And this is actually a comfort zone for me as a reporter, not writing about the culture wars or not writing about squishier topics like that. Is it how, I'm told, well, how are our public officials misbehaving? And if I hadn't been finding some problems, I probably wouldn't have been kept on the story. And so this becomes a story of how, are the police following their rules? Is the prosecutor adhering to the laws? Is he following the rules that Tom was talking about? And I've gotten a lot of support at the paper for doing that. The News and Observer has a long history of watchdogging state and local government, as Patrick Baker and Jim Black and others, could tell you. And I'll leave you with one final thought. It's just a way to approach stories. If you think, if the story's about if you think that there's wrongdoing, how do you know that wrongdoing is going on? How do you know that things are being done wrong? Well, the first thing you need to know is, well, what is right doing? Every reporter covering cases like this, you go and you read the rules. How is it supposed to work? How is the prosecutor supposed to behave? How is a lineup supposed to be run? How is evidence supposed to be handled? And, just learn the rules.
I want to begin with what may seem a partial defense of Mike Nifong. When Wen-Ho Lee was prosecuted for 8 or 10 months, and it turned out that there wasn't a case and that the prosecutors and the FBI had misbehaved, When John Demjanjuk was sent to stand trial for his life as the alleged Ivan the Terrible of Treblinka, and a prosecutor assured the judge there was no exculpatory evidence, and at that moment he had in his locked briefcase 6 sworn statements that contradicted the prosecution's case. When Ed Meese on a fine afternoon announced that Congressman Ronald Dellums was dealing dope out of his chambers, and that was a big splash. I remember going down and, all we knew was that the allegations had been made, and I talked to Ron. He said it didn't happen, and the only answer I could make to the press was, well, we deny the allegations and we're looking for the alligators. When the Innocence Project finds that more than 100 people were on death row and were actually innocent, many of them because of prosecutors and police withholding evidence or conducting investigations that pointed at the wrong person, I sit here and ask myself, where is the jurisprudence that in any significant number of those cases has brought prosecutors and police to account? The Nifong case will serve us well only if it is a first step towards addressing serious injustices in the system. And we need to be clear about our perspective. I'm biased because I'm mostly a defense lawyer, kind of like with Mae West and Lloyd Nolan in that movie where he's the district attorney and he says, "Have you ever heard my ethics questioned?" And she says, "Honey, I've never even heard them mentioned." Well, I think we have to start by asking ourselves the origins of not the new Rule 3.6, because in Gentile versus the State Bar, 5 members of the Supreme Court held that old Rule 3.6 was unconstitutionally void for vagueness. And Justice Kennedy wrote an opinion, some of it for 5 justices, some of it for 4, that's really magnificent. And I saw him several months afterwards, and he said, "Well, how'd you like it?" I said, "It's really nice." And he said, "Well, I was really trying to channel Justice Brennan." And it's true that Kennedy would go hang out with Brennan, to the point where Rehnquist wrote Brennan a letter saying, "We could find you chambers out of the court building that would be a lot more convenient for you to work." And Brennan wrote back and said, "No, thank you." Dominic Gentile represented a man named Grady Sanders. Grady Sanders owned a private vault company. The Las Vegas Metropolitan Police stored drugs and money there to use in sting operations without telling Sanders that they were doing it. The drugs and money went missing. For 6 months, there was a drumbeat of publicity that said that Sanders had stolen the drugs and money. Sanders was indicted. The night before arraignment, Dom Gentile went to the library and read up on model rule, what was then the Rule 3.6, what he could and couldn't say. He went to the arraignment and found the trial would be 6 months later. He decided to hold one and only one press conference that day. 6 months later, when the trial was held, no jurors remembered that press conference, although some did remember the conferences the prosecutor and police had held. And Gentile did present evidence in support of his theory, and Grady Sanders was acquitted. 2 weeks later, he got a letter from the State Bar proposing discipline for his one and only one press conference, even though the prosecutors and police never faced discipline. And he had the courage to say no to a private reprimand and take it to the Supreme Court of the United States. What did he say at his press conference? He said that, in fact, Las Vegas Metropolitan Police sergeant named Steve Shaw had taken the drugs and money and put the drugs up his nose and spent the money. Now, that's a matter of public concern. And that is, of course, the position of lawyers. John Adams wrote in 1808 that then and there was the child independence born, speaking of lawyer speech and against the British writs of assistance. He evoked the same theme in a letter home to Abigail on July 3rd, 1776. He said, "Honey, I'm in Philadelphia, and it's a holiday tomorrow. All the stores will be closed, and there'll be fireworks and so on. But I do remember that free speech that us lawyers did." So that the idea of lawyers with a dual role, both as clients, as advocates for their clients, and as public citizens who have a unique perspective on the social issues being raised by litigation, and this in a country in which it's hard to think of a significant social issue that has not been the result of significant litigation. It's one of the saving graces of our constitutional system. And so lawyer speech is important. And it is important not to get on a bandwagon that curtails lawyer speech or identify that as the culprit. It is certainly, I think, the culprit, credulous media folks can sometimes be the culprit, and it's kind of inherent. If you have a reporter always at the police department, that reporter is going to hear what the police department has to say, and may sometimes be tempted to run with it uncritically. But Mike Nifong's alleged press conferences, he tried his case in the press, right? And that sticks with jurors. When we get to use questionnaires in high-profile cases and jurors have a chance to think about what they've read, whoa, it comes out. They've read it, they're influenced by it, and they cannot credibly assure us that it's out of their minds. As I said to a juror in the Nichols case, when he said an answer to a question that the judge had asked, can you put that publicity out of your mind? He said, I think I can. And I said, well, sir, my wife Jane is sitting here, and if she said, honey, do you love me? And I said, well, I think I do. She would ask me another question, and with all respect to you, sir, I'm fixing to ask you one, and so just bear with me here because we're trying to get a good jury. So we can prove that it has an effect. Now the second thing it does is that when you as a lawyer get out there and have your theory of the week, like Steve Jones did for Tim McVeigh, and I've said this in public, and Steve knows it. He had the conspiracy theory du jour. And after a while, prospective jurors begin to lose confidence in the lawyer, and that carries over. Mike Nifong gets out there, and he does a distinct disservice to people that want to bring complaints of wrongdoing. If you know that your complaint of wrongdoing, the next person who comes along, is going to thrust you into a media firestorm in which your own dignity and the possibility that you may think better of it, or that you misremembered to begin with, all these human frailties, whatever they are and however you got them, you'll be less likely to come forward. And the third thing, and that hasn't been mentioned up to now, is that he derided people who invoked their constitutional rights to counsel and to not be the instrument of their own condemnation by choosing to remain silent. Now, unlike such things as the exclusionary rule for Fourth Amendment violations, which some people can call a technicality, those rules about counsel and the right to silence have to do with reliable outcomes. Just as rules about not fanning the flames of adverse publicity have to do with reliable outcomes. They therefore compromise basic values of the system. So that is a perspective. Now, again, to end where I began, I don't want you to say that the culprit is lawyer speech. Of course, prosecutors, lawyers know better. But there are remedies if for reasons unrelated to lawyer fault, or because the media is doing its job of reporting on matters of public concern, or because lawyers are doing their First Amendment rights, maybe you need a continuance. Maybe you need a change of venue. And so I conclude with some words that I spoke to Judge Mage, and that's why I put the site up there when he moved the trial out of Oklahoma. And I referred in this to Governor Keating of Oklahoma, who's a lawyer, who said, believe me, those boys will get a fair trial and we won't execute them until they've had it. And that, I'll tell you, it was a little over the top. And I said this, two roads diverge before us, gathered as we are with the decades of constitutional liberty piled so high, the anguish of the victims close at hand. To one of those roads we are beckoned, from sadness to anger to vengeance. Governor Keating beckons us along that road by what I suggest is deliberate design. The media have beckoned us along that road simply by their desire to serve their market. The other road I suggest to the court is the one the framers laid out for us while the memory of unfair trials in distant forums was fresh in their minds. We neither dishonor nor deny the grief and anger of the victims, nor even their cry to vengeance. Your Honor, this is my 30th year in the law, and I believe more than ever that when we summon anyone, Terry Nichols, into court to find out whether he's going to live or die, that it is our job to construct where we best can a kind of sanctuary in the jungle. And that is the challenge, to accommodate the needs of a free society that needs to think about and evaluate the great social issues that are tendered by these cases, to the building of that sanctuary, which is a part of what we are about in our profession.
Thank you. Thanks to all the panelists. We have some time now for questions from the audience. Because I suspect we're going to have a fair number of questions, I'm going to ask all of you to be brief in posing your question. And also, for the sake of the panelists, I'm going to ask you to state your name and identify how you're connected with Duke or not connected with Duke at all.
Sarah Beal from the law school. Mike, do you think that within a First Amendment framework where the press does have an economic advantage, we can get that sanctuary, or would you prefer a British system where there's no reporting during the pendency of the case, but when it's over, then all those big issues can be discussed?
I am for the American system. The abuses that were found in Great Britain in the Irish cases, with the faking of evidence and the false, the police and prosecutorial misconduct, a vigorous press can help you out. And it has in cases that I have tried over and over and over again, because nobody's going to talk to our investigator for an allegedly killed 167 people, but they'll talk to the New York Times. We put on 80 witnesses in the Nichols case, and a majority of those we found because they talked to the media first. So I understand there are risks. And that's why I put up the site to our brief in Gentile, the Westlaw site. We talk about those options. And that was a subject of a lot of the oral argument.
I have a quick question for Joe, if I could. Oh, was there one? Okay, if I get a chance.
Sega Phillips, I'm with the law school. I was wondering, do you think that there really should be no similar limits on what defense attorneys can say? Granted, two of you were defense attorneys.
Yeah, I'm not sure I said there should be no. I just say it's a very different situation for the prosecutor. But go ahead, let these defense lawyers chat about that.
Well, I mean, I think the rule itself, Rule 3.6, recognizes that, when the prosecutor talks about the case, then the defense lawyer has to do something to try to, even the playing field. But I think I agree with Mike. I think lawyers being able to talk about their cases and about the, issues, I think that's important, and I think it's part of, how we sort of keep track of things like this case. I mean, I think it was important in this case that, that Joe kept on it, and eventually Nifong withdrew.
Yes, of course there should be limits on defense counsel. And also there are practical limits. You don't want to be out there, as I said before, retailing your case. You used to say to reporters, Judge Mates likes to think he's the guy that's hearing it first, so we're going to say it inside there. And similarly, we would not engage in soundbite reporting, where they could chop your statements up and put them in, because there you can create problems. So there are common sense things that go on top of the constitutional rules. It requires you to accommodate these different values, and that's what the new rule tries to do, that the Supreme Court said the old rule didn't do.
I think this maybe goes to Professor
Michael,
Metzloff.
say who you are.
Oh, yeah. Michael, Michael Frandina, I'm a student here at Duke Law School. It seems like there's been several high-profile rape or sexual assault cases that all tend to show the general public that this is maybe an over-reported and it's sort of a weapon maybe used by women, whereas what I learned in criminal law is it's a very underreported crime. And so I feel like one of the rules that you cited says if it has a negative impact on kind of carrying out criminal law, and I wonder if that's something that gets taken into account. In other words, if his statements lead people to believe, and then, as Professor Tigar said, sorry if I mispronounced your name, leads less people to actually report the crime, if that's something that
No, you're right.
Well, I think that's the point that Professor Tigar mentioned, whether it's taken in consideration by the bar or not, it has that effect. And it, my guess is that it likely will be taken into consideration by the bar when they look at this case.
I mean, it's hard to think, how do you prove that or establish it? And, I think that's one of the questions as we look forward to the trial in the ethics case is, what would this have been if Mr. Nifong had said what the average district attorney would have said? And that's a question when Joe was interviewing me last week. I asked him, I guess I'm too much of a law professor, so let me ask you a question. And that is the question I have in mind, what does the world look like in this case? Because there was always going to be interest in it anyway. But what would this world look like if the comments of Mr. Nifong had been within the sort of range of what's normal? And I don't know if anybody's got a thought on that, because I think that's kind of the ultimate question here. And it does impact how we all think about it, and how we, what would, if this was us, how would we report it? What would we do? What confidence do we have in the justice system?
Judge Maitch, in that opinion that's up there, the F subside, takes into account the expert testimony of Scott Armstrong about the relationship between media coverage and community attitudes, and then a professor from California, Professor Bronson, that tries to answer some of those questions. So the answer is that, there's Daubert qualified, scholarship out there that could answer that question with some precision, I think.
Yes, I'm Erica Williams, and I'm a law student as well. When Professor Coleman was sort of citing his criticisms of Nifong, he had both the sort of criminal justice criticisms and then also all the things that he said that were maybe more societal comments, sort of the introducing the negative race relations and his commentary on Duke students. Now that we've sort of got Nifong being dealt with, and we've got a new prosecutor in the case that's hopefully going to make sure that the accused get dealt with, I think those two issues may get resolved ultimately positively. But is there any way to ever sort of go back and fix maybe some of the other problems that his comments created, whether it was dissensions within the city or negative impacts on how Duke is viewed nationally? I mean, how do you fix, or can any of you have any commentary about whether that's ever going to?
We could ask John Burness in the front row. I think it's been an issue. How do you deal with that? How do you put that back in the box? And Joe, how does Duke deal with this now? I mean, is this a Duke problem that's real, or does it just time will tell, and we'll go on doing a good job, we hope?
I really have no clue on this question. I mean,
Is that something you, as a reporter, obviously you're trying to make sure that the public gets a now correct view of the case itself, but you also feel like it's your obligation as a reporter, and maybe you didn't cover as much of the meta story before, so you don't feel the need to correct it, but do you think it's sort of those reporters that did cover those aspects, is it their obligation to go back and reevaluate or those things again?
well, I think it would be our obligation as an organization to go back and talk to people who said the things they did maybe in March or April. We would have that obligation. For each organization or person who feels they're maligned, I would hope that they would, seek us out and say, please, I want to be heard on this, and we'd give them an opportunity. But,
Neil Siegel at the law school. For Tom Metzloff and Jim Coleman, my question is, based on what you know now, if Mr. Nifong is judged guilty, what sanction would you recommend? And for Mike Tigar, my question is, how far would you push the First Amendment argument? Should Nifong be protected from civil liability for defamation when he travels to New York and gets on Good Morning America and says really whatever he wants about the case? Certainly suggests strongly that the defendants are guilty, right? Would you say that the First Amendment would shield him from that kind of a civil lawsuit?
Well, these are, allegations, and so we should start with where Mr. Nifong should have started. Wait yet to be proven. We have to put them on. The facts about the statements are there. I mean, we've seen them on television. The comments about the DNA and the withholding of evidence, I think, may very well be filtered through the trial judge. He certainly has concurrent jurisdiction to look at that. So there's some caveats there. I think it's a very difficult question. I think the starting point would have been, for the publicity issues, a reprimand. and that would be normal. I think they're more serious than that. I think we are looking, if everything is established, at least at a significant suspension.
Yeah, I agree with that, too. I mean, I think that he has caused a great deal of damage, both to Durham, to Duke, to the criminal justice system. And I think that the behavior was intentional and it was, systematic. I mean, it was, he repeated it, and I think it's hard to justify not taking some action that gets his attention and the attention of other prosecutors.
The libel or slander question. Now, Good Morning America is in a better position in the libel case than Nifong is. I rather doubt that the lacrosse players are public figures, at least at the outset of the controversy. Therefore, he's got a hard time finding New York Times against Sullivan safe harbor, and therefore cannot be shielded by the requirement that the plaintiff establish constitutional malice, which is not ill will, but simply knowledge of falsity or reckless disregard. I spent a lot of years representing the Washington Post in libel cases, and I tell you something. If somebody, I don't know what the Post did in this, but somebody sent that story over. He appeared on Good Morning America this morning and said such and such. Well, I'd want to go over and talk to Woodward about whether this really needed to be in there in that form without considerably softening. Now, the Second Circuit has this public controversy reply doctrine, because Irving Kaufman loved the New York Times, that carries it a little bit further. But even there, if that's the call. If I was making the libel read, I'd say be very careful, because, runs into money.
You would agree that there are limits to lawyer speech?
Absolutely. No, and lawyers, you see, the problem, Professor Siegel, is that because the lawyer is in the best position to know, having access to the facts, the lawyer's New York Times defense may be more difficult than the media's defense. The media can say, well, the district attorney told me, right? That's a good source. That passes the standard. But the lawyer's got access to the case file. So that's, in Times against Sullivan terms, that's different, in my opinion.
I think what he's asking is if,
Oh, I didn't answer the question?
I don't think so. To follow up his question, are you okay with a significant sanction against Mr. Nifong in this case, given your concern with the First Amendment issues of lawyers?
Oh, you bet.
Okay.
Yes, thank you very much. I'm sorry.
Your takeaway was...
I was thinking of running for president, and I'm practicing not answering the question.
Professor Alexander Hardman, in computer science. My question is, if a media outlet, like the newspaper, reports that a particular person, Mr. X, says something that's libelous, that turns out later to be libelous, is X responsible, or is the media outlet responsible for both? The reason I ask is because it relates to anonymous sources. First of all, if you can reveal the name of your source, it might reduce your liability, so relying on anonymous sources. And so how does it change with anonymous sources? If an anonymous person says something libelous, is the responsibility on that anonymous person or on the media outlet that reported the libel of an anonymous?
I need help from the lawyers on that.
Tiger used to represent newspapers, so that's him.
I would say probably both.
The newspaper needs a good faith basis. That is to say, they can't know it's false, they can't recklessly disregard whether or not it is. And that has to do with the quality of the source. That was the whole, Deep Throat thing. They would go down there and meet Bradley and Simon every day, and that was the question. That was, that they were wrestling with. Whereas the source himself or herself, obviously, as I'd said in answer to Professor Siegel's question, they're closer to it. And so they don't have that insulation that Times against Sullivan was designed to create for the media?
Allison Rice, this is really a question for Tom and Jim. In the context of what the North Carolina State Bar has meted out to prosecutors up till now in some very prominent cases, including Allen, which Joe reported, how do you get to thinking there'll be a serious sanction in the context of what's happened previously from the State Bar?
Well, and I think probably Joe has some comments on that. The chair of the hearing committee is the same person who was the chair of some of those other hearing committees, and neither of the sort of two most prominent cases resulted in serious sanctions. My recollection of the one case was there was quite a bit of evidence put on about the good character of the two prosecutors involved, and in a sense it was, there's a list in the rules about mitigating and aggravating circumstances. And one of the mitigating is, a good, clean record and for a long period of time. I'm sure Mr. Nifong will have at least the 5 character witnesses that are allowed and affidavits from many others. So the question is, where's the sort of aggravating circumstances? One of the aggravating circumstances is selfish motive. And normally that's money when you talk about lawyers. The other case that's pending now in the State Bar is the fellow from Chapel Hill who absconded with a couple $1 million from his clients, and that's sort of the normal thing. That's a pretty easy case. The selfish motive here is an interesting one because it really is the speculation, or at least the belief, and Jim mentioned this, about the nexus with his election, that this came right before his primary, and a sense that he had to, I don't know how you prove that. I mean, the facts line up and the times line up, but certainly if there is evidence of that nexus, that certainly is a very strong selfish motive. I think it's the number of statements. It's the fact that it's multiple offenses, both the pretrial publicity issues as well as now the candor to the court issues and the failure to turn over exculpatory evidence. So we do have multiple offenses now, all of which are serious and extensive in their own right.
I also think that the criticism that the bar received as a result of how it handled the 2 prosecutors in the Allen Gale case and how they screwed up the attempt to prosecute Ken Honeycutt, another prosecutor outside of Charlotte, probably means that they are looking for some way to indicate to the public that, in fact, they can be an effective watchdog. So my guess is that that is going to be a factor, whether consciously or not. I think it's certainly going to be a factor in the punishment in this case, and my guess is that that's why he won't get off with a reprimand.
Yeah, I think you'll see a very different hearing at the State Bar than you saw in Allen Gale. For example, Tom mentioned the character witnesses. David Hoke and Deborah Graves put on a slew of character witnesses, former justices on the Supreme Court, Court of Appeals, head prosecutors and all. And they did this during the evidentiary part of the hearing. And not in the sentencing part of the hearing. So you're here and you're trying to decide whether something was wrong or not, committed wrong, and you're hearing from all these great character witnesses. And normally the character witnesses would come after you found the wrongdoing, you're trying to decide the punishment. Well, there's a huge outcry after they issued the reprimands in the Gale case. So that's one of the things you'll see different. Another thing is that the Gale case was, they put on a few pieces of paper and rested. The bar didn't rest it after 20 minutes. They didn't talk to the chief investigator in the case or any of the. It was just a very tepid, and that's a charitable word, tepid prosecution. And this time around, they have gone outside the State Bar and hired a very competent lawyer to prosecute it. And from everything I see in the paperwork, they're prosecuting very vigorously. So I think it'll be very different.
Yeah, yesterday at the hearing, they talked about it anticipated to be a 4-day trial, which I think will actually be more than that, but that's certainly not 20 minutes.
Yeah.
I would think that character evidence would be admissible in the case in chief, because there is a scienter requirement here, and questions of good faith and so on, it's a little hard to pin down the scienter requirement, but it's the inability to know the standard that caused the Supreme Court in Gentile to hold the rule unconstitutionally void for vagueness. So that would make it implicit that there's some issue as to which character evidence well, it's kind of weird evidence anyway in the law of evidence, but would be admissible in that phase of the proceeding.
We are out of time, so thanks to all of you for coming. And thanks for